I've known him 2 years.
We both have.
And you too?
Way back.
Me too. 35 years ago.
Yeah.
Oh.
Yeah. Yeah. Fran, how are you, dear?
Me too.
35 years ago. Yeah. Hey, good morning. Yeah. Yeah. Fran, how are you, dear?
Me too.
35 years ago. Yeah. Hey, good morning. Yeah. Yeah. Fran, how are you, dear? Yeah. Hey, good morning. Yeah. Yeah. Here's what I have.
No, I don't. जी बोलो अच्छा वो उसका वो फिट हो गया क्या मगर आपको वो कहा गया था डाउन हो चलेगा How about that?
Okay, just let me know. Okay.
Okay, yeah, we've been kind of chit-chatting.
नहीं
So, I'll let her.
it's your compliment.
No, I know the name of it.
जल्दी करो मीटिंग है मेरी
Okay, yeah. Yeah, we really.
नहीं रिजल्ट्स वालों में काम कर रही हो ये तो ये मैनेजमेंट है
I like them too. The way she exits here. Not even. Maybe I didn't note my box. How many students see me? I mean, I didn't do anything. You guys weren't that mean. I'm not sure. I'm not even sure what happened. To be honest with you, I have no idea. Pick up, yeah. Our son. Oh, Corey Bullard.
Yes.
Yes, the name of the private professionals.
Yes.
Yes. Oh, yeah, that was terrible. Jacob walked out with Corey. I love Corey.
Did you?
Yeah. I had a great relationship with Corey.
Me too. And she
Oh, she was lovely. Oh, yeah. But she was very sweet.
Okay, well,
Yeah, Jacob really, that was not good.
I know, and Jacob was a nice lady.
Oh, yeah.
Heard of that. Yeah, well, interesting how that.
Hey, Kristen.
Yes. I just hit you. That's, I have my own. Did you make some extra ones? That's not staple. Huh? And that is not staple. So what? I don't need a staple. Extra special service. Who did those? I had
Oh, you did? Well, I didn't have all the numbers, that's all I care about.
I just don't want that.
There's only one that I'm not that familiar with, quite frankly.
Which one's that?
Oh, the last one about the images, I don't remember that. I have, Jean always thinks that my listing packets are interesting.
Talk about the
Images, what about,
ownership of them?
yeah.
Yeah, that's new in the last year.
Well, thank you.
Yeah, that's new. Because that's come about since I got it. Because I started noticing that last year.
us. If you go back and look at some of the stuff that's about marketing more, some of the deacons who pulled down everything out of the front door.
Okay. Nancy gave me a candle that was so I got it make her sign. My candles.
Yeah, no, I can't.
Can't have old candles.
One of those lovely little genetic
None
gifts
of them,
my
you don't
mother
like
gave me.
them?
That's something I don't like. It's a strong scent at all.
Oh, really?
Maybe you should behave yourself this time.
Yeah. I haven't touched it, but anyway.
Something like that.
Oh.
Hey, you're on the wrong side of the table.
What?
No, that way she's right behind the vision.
You can't sit.
She knows her network every 10 minutes. She knows exactly. That look, and she shakes her head at me. Look, see? This is
Hey,
again.
Marcus been down there. She's fine right now.
Bye. See?
Hey, Bonnie. Yeah.
This is the perfect.
Oh, man. You had to.
You want to just have the.
Good morning.
Mary Ann was sitting there and I was. Yeah. she is.
Go there.
I know. Same thing. They got the holes underneath.
Never mind. I had our first transaction together. Our very first transaction we had. What was with Marianne? Marianne, wait. That was her first transaction and mine.
Oh, really?
Yeah, I'm looking at it.
I know, but they, unless they know, we can take this one out there and show it. Dan knows what they're doing now, because he put it underneath before, and they, somehow they still got up on top and cut it, so now he knows the whole thing's gotta be done.
I'm not a highlighter. I don't highlight.
I'm glad you like it. You all need something?
Good morning, how are you?
Oh, I was listening.
Now it's.
You said something and I'm listening.
Board up there.
You don't want to tell me.
So I said, you're gonna. Hey.
Half one down and then.
Who's your special?
What is it? We just picked them off that table.
It's just that some information from a transaction that I really shouldn't be saying. That's what it is.
Probably Debbie's.
Huh?
Debbie's?
I don't know, because I never saw it. No, it's probably information you shouldn't have either.
What street?
I'm a broker.
What's that street?
You're not a broker.
Oh, I'm missing something.
Man, I tell you, I slap him silly.
Oh.
No, this is at my, yeah, no, thank you.
No, thank. Wow, it's that easy to.
I'd rather have a spanking.
You'd rather have a spanking? I can hold this.
Too old for that way.
I used to spend my kids with this pastor special.
You know, my mom used to.
Good old days of capital punishment.
No, no, and then one time I walked out of the bedroom and the two of them said, and the one said, I didn't know who you were.
My mom used.
Morning, how are you?
How are you?
Good, good.
A oak board from the hardwood floor. That's what my mom hit us with.
Well, my God, it looked.
Yeah,
What should I say about my kids?
It had to be.
Oh, something coming.
Do I have a
Why
copy?
is that going three?
I don't have any extra copies. We
Really?
emailed all that.
You know what? I've heard that.
Oh, there was an extra copy too. Thank you. All right.
And they're saying about all the guys like Terry Hayes, everything in 1950, every single thing in
I'm gonna
1950.
take that as, that's
Every
age,
single
what do they call that, age harassment, Bill?
Hey, you know what? I'm 65 now. I joined the club.
Hey, I'll be 60 this summer.
I'll take a 60 club.
You can get an AARP when you're 50. Bill's getting an
Say
AARP
we'll,
for a bunch of years now.
say we'll be in the 60 club this summer.
60, new decade this summer.
Yeah, me too.
We're gonna start a new decade this summer, yeah.
I'm 2 days after you.
I don't know when my wife is.
My
wife
ooh,
is-
I tell it all the time. I can tell you.
Nothing wrong with being an AARP.
You know,
That magazine arrived on my 50th birthday.
Well, ouch, ouch.
And the senior man, I'm eligible for every senior man. I ask, I always ask, what's the difference between the portions? Is there any portion difference? Oh, we just don't put salt on it.
462.
No, I made it up.
Sounds awesome.
Too loud.
Be quiet.
Listen, I don't come to meetings very often, and you give me the push up on your loud a couple times already. You don't want me to come to say something.
That's Mary Ann's.
I told her.
That's true.
I know all this already because I read it.
Marion, are you coming?
I didn't tell you no.
She's here.
I might have said you.
Hello?
No, you did. Don't tell me.
Are you Marion?
You looked at me and gave me that.
Oh, okay. I thought you
All right, hey, we ready to get started?
Quiet.
Let's get
Debbie
started.
said- Debbie said, can you wait on her? She had to go on her walk.
Oh, it's coming.
That wasn't very many steps.
I'm also always answering to Debbie. All she did was take Michael's place.
Well, everybody needs somebody like that.
Hey, I got more than one, believe me.
got
All right, today we're going to talk about listing agreement, some of the other related documents. So you should have your packets there. And I will tell you, as trivial as this sounds, one of the most important documents is the agency disclosure on a listing agreement. And this must be signed.
That's what's number one.
Technically, it's supposed to be signed before you actually take the listing.
Right.
And so most everybody gets them signed about the same time. So you're okay as long as you don't time it, you know? But the fact of the matter is that, yeah, well, the fact of the matter is that if you don't have a signed agency agreement, you don't have a deal. And that's enough for a seller to contest paying the commission. So you can lose your commission by not giving the seller an agency disclosure. So make sure you get the agency disclosure signed. That's pretty much all I'm going to say about that, except for the fact that we only have 2 agency disclosures now. You don't have that third one anymore. So you get the listing agreement signed. That's the only agency disclosure that the company's going to ask you for. Debbie's not going to ask you for that other one that comes in with the offer and the seller is supposed to sign it. This is all you need. And on the other side of the transaction, when the buyer signs your agency disclosure, that's all you need. You now only need 1 agency disclosure in your file, unless you happen to be double-ending it, then you would need 2. All right? So there's no more confusion on that anymore.
And you don't have to initial the second page either.
Correct. Don't worry about that. The representation of more than one buyer, the dual consent. The only thing I want to highlight on this is towards the bottom where it talks about offers not necessarily being confidential.
Okay.
And so you got to make sure your clients understand buyers advise that seller or listing agent may disclose the existence, terms, or conditions of buyer's offer unless all parties and their agent have signed a written confidentiality agreement. So unless the buyer gives you, the listing agent, a confidentiality agreement to sign when they submit their offer, technically you can share that information. Your job as a listing agent is to get the seller highest and best terms. So if a buyer submits an offer, which most of them do nowadays, without the confidentiality agreement, and you decide okay, you know what, I got this offer, I got another one coming in, and an agent calls you and says, hey, Greg, how you doing? What's the best offer? You can tell them. You can tell them. Because, again, your fiduciary duty is to that seller to make sure that you're going to try to get them the best number, price, and terms. Unless you've signed a confidentiality agreement that says, unless the buyer submitted a confidentiality agreement with their offer saying you are not allowed to share this information with anybody. Okay? So, again, you don't have to do that, but this is notifying the buyer that that can be done. All right? It can be done. There's nothing illegal about it. The wire fraud transfer is pretty self-explanatory. All right, so let's get into the listing agreement. Let's start on the very top with the seller. And seems like a simple concept, but make sure that you're dealing with the right seller. Okay? So if you know you're going to take a listing, you can check things on the tax records, but I would tell you should always follow up with at least either a prelim or a property profile to make sure you know you have the right sellers.
Yes.
Okay? And if you see something with a trust on there, then you know that you might have to use the representative capacity document, you know, the RCSD. So now for us, in the case of a living trust where the sellers are both alive, it's just that they hold their property in trust, we're not real sticklers on the RCSD, you know, because they're both living. But the seller in that case is the trust. So you're going to have to put the name of the trust as the seller, you know. So, and then whoever the trustees are. And you always want to verify in those scenarios. On the living people, it's not so difficult. But when you're dealing with an estate, then you got to make sure that you're dealing with the right person. And when you are dealing with an estate, we definitely require the RCSD. So if you are dealing with a trust, then what you've got to do is you at least have to get a copy of the page of the trust that shows who the trustees are. Is it a successor trustee situation? Is it a co-trustee situation? Because if it's a successor trustee situation, then you're probably only going to be required to have one signature. If it's a co-trustee situation, it may require 2 signatures. Okay? And a lot of times what ends up happening is you'll deal with somebody on a trust who says, well, you know, I have power of attorney for this trust. Okay, in most trusts, powers of attorney are not allowed. So somebody who's dealing with a trust who says, well, I've got power of attorney for my mother and father, and their property's held in trust. And let's say they're both living. And you're dealing with somebody who says, well, I've got the power of attorney to handle this for mom and dad. Then you have to verify whether their trust allows for a power of attorney. Because most of them don't. And if it doesn't allow for it, now you're stuck with potentially 2 scenarios. One, if mom and dad have capacity, then you need to have them sign the listing agreement. So as long as they're competent, they don't lack capacity, they were just being, I don't want to say lazy, but they just thought it'd be easier, just let my son handle it, my daughter handle it, I'll give them power of attorney. It's not that simple. So you either go to them and have them sign, okay, and their trust again is a seller, or you look at the trust and see, is the son the successor trustee of the trust? Because if the son is the successor trustee of the trust, even if they're living, they can resign. They can resign their position as trustees, and it would go to their son as a successor trustee to sign for them. And that's a legitimate way of doing that. So they would have to resign in that scenario, and then you can have the son sign here on the representative capacity. You have to take the page of the trust that shows that the son is authorized there. And if it was a case where they resigned, you'd want that resignation letter also. You'd want to put the resignation letter in there so you can show the paper trail as to how the son got authorization to sign. Or you would need a letter from their physician that says they've been declared incompetent, they lack capacity. And in that case, the trust usually has a provision in it that says If any of the trustees has ever been deemed to lack capacity, then it goes to the successor trustee. Okay, does that make sense? Okay.
If it doesn't say that,
It will. It will, because if it doesn't, you have to get a court order. You'd have to go to court and get a judge to rule that they're incompetent, they lack capacity. But most trusts, that's just standard language. So again, make sure that you have the right seller. Make sure that you know you're dealing with the right person. And if you've never met the seller, you don't know them personally, don't be doing stuff via DocuSign when you've never met them. There's just too much fraud there, or potential for fraud. So if you don't know these people personally, you need to bring them in here. You need to meet them, and you might even need to check their IDs to make sure you're dealing with the right person. Because when we get to the end of this agreement, there's a warrant section that says they're warranting that they are who they are, and this is the right person, but you need to do all the due diligence. It's on you. All right? All right, so hereby employees and grants, it's Legacy Real Estate Associates. Your beginning date, you have to have dates on your listing agreement for them to be valid. You can't put a TBD in there. That is not valid, and if you did put a TBD, they could cancel the listing because it's not a valid listing. You have to have a start date and an ending date. Okay? So that's what you got to do there. And if you're going to get a listing and they're saying, well, you know, we're not quite ready to go yet, but you know, why don't we post date the listing a week? Do not do that, because somebody else can come in and list the property out from underneath you. All right, at least for that week. So you can tell them, look, we have a provision. We'll get to the SELM. You don't have to go on the market right away. So if they're ready to sign, get them to sign. The listing date starts that date. If you think they're going to be taking longer to get the house ready for sale, then you may want to push the end date out. So if you were normally going to take a 90-day listing and they told you, wow, I need 30 days or 40 days, then maybe you're going to take a 120 or 150-day listing. So that way you know you're getting the market time that you want to get. All right? Then all the stuff about, you know, the property described as, etc. I don't need to go through that with you. Listing price, again, make sure you have the price in there. You can't put TBD on the price either. If you think you're going to change the price later, then just do an MOT. Put a price in to start. Do not put TBD. Now, on the price piece, just like on the commission piece, maybe you've got this listing already filled out. It's ready to go. You've got dates in there, but you don't have the price because you're not sure what the price is going to be, and you don't know what you're going to ultimately decide on commission. And you decide, I'm going to leave those blank. And I'll fill them in when I get to the house. If you do that, then they need to initial those handwritten sections in order for them to be valid. So if you decided to write the price in later, then make sure that you put the price in and have them initial next to that. If the commission is going in later, same thing there. Okay? Now when you come down to 3A, seller agrees to pay the compensation for services, and you've got the commission, whether it's commission or dollar amount, and if you wanted to charge anything additional on the end, you would put it there. So if you were going to charge them for a TC fee, it should go there. If you wanted to charge them our business operations fee, it should go there. So any additional fees you want to charge them, you put that there. That's the spot for that. So A1 is if during the listing period or an extension, broker, cooperating broker, seller, or any other person procures a ready, willing, and able buyer whose offer to purchase the property on any price and terms is accepted by seller, provided the buyer completes the transaction or is prevented from doing so by seller, which means a seller default, broker is entitled to compensation whether any escrow resulting from such offer closes during or after the expiration of listing or any extension. So if you put a deal together, this question comes up. I just had this question the other day. An agent called me and said, man, I got an offer coming in. My listing is going to expire. Do I need to extend the listing to be able to work on this offer? Because by the time it closes, the listing is going to expire. The answer to the question is no. If you go into escrow prior to the listing expiring and you still close, you're entitled per the listing agreement. Your concern would be that if the deal were to fall out and you're past your listing expiration date, you are now expired. So you don't get to have that. So if you're worried that, well, if this deal falls out, I want to make sure I still have the listing, then bless you. Then you want to have an MOT. Then you want to get an extension, some type of extension of the listing. But you are entitled to your commission so long as you go into escrow prior to the listing expiring. You're also entitled to your commission if the seller causes a default. You could theoretically sue the seller. Generally, that doesn't happen. But if you knew for a fact that you weren't going to get the listing after it expired and they were the ones that caused the deal to fall apart, you may try to go after them for some compensation. All right. Number 2 is your safety net provision. If within blank calendar days after the listing. Too many of you guys leave this blank. Okay, too many of you leave this blank, which gives you no safety net provision. So that's a 0 days. And this is the whole thing about procuring cause right here, if you want to have a good procuring cause case. I go 60 days. So I usually will put in 60. You can do 30, you can do 60, you can do 90. And all it's saying is that after the end of the listing period or any extension, after any cancellation of the listing agreement, unless otherwise agreed, if seller enters into a contract to sell, convey, lease, or otherwise transfer the property to anyone or that person's related entity who physically entered and was shown the property during the listing period or any extension by a broker or a cooperating broker, or for whom the broker or any cooperating broker submitted to seller a signed written offer to acquire the property, seller shall have no and obtain option. Seller, however, shall have no you would be entitled. Seller shall have no obligation under the broker in this paragraph, unless not later than the end of the listing period or any extension or cancellation, broker was given has given seller written notice of the terms of those buyers. So it used to be that you had 3 days after your listing expired to turn in a list of names to the seller of people who saw the property. That's not the case anymore. If you're not going to get an extension on the expiration, you need to turn those names in prior to the expiration. And you may not even know the name of the buyer, but I would at least turn in the name of the broker. Okay? Now, it's easy when you have offers that were submitted. Then you can turn in name of broker and buyer who already submitted offers. It's a little more difficult when people are just coming through your open house, or because if you don't get their name, you're not going to be able to submit them. But if a broker was showing it, you might be able to say, hey, you know, so-and-so from this company showed to a buyer. Okay? Because what you're trying to do is prevent anybody, buyer, from going around you, waiting for the listing to expire, and then go working out a deal. You know? And we've seen that happen here several times. And I've been to several arbitrations on behalf of this office, and we've won every single one of them on procuring costs. So we've seen it happen. You know, we've had several big cases in here. And I'm talking like $50,000. Okay, so, but if you don't have that protection, you're out. You got 0 days. You got no protection whatsoever. Okay, so make sure you put some days in there. Otherwise, it's 0. All right. Number 3 is if without broker's prior written consent, the property is withdrawn for sale, conveyed, leased, or rented, otherwise transferred or made unmarketable by a voluntary act of the seller during the listing period, you would be entitled to compensation. So if the seller really says, look, take it off the market. I just want you to take it off the market, period, and you take it off. You're still under a valid listing agreement, but they've actually made it then unmarketable. Technically, you could go after them for a commission. From a practical standpoint, you may not want to do that because you always have to be thinking about that. Because especially if you're working in a neighborhood, you don't want that seller talking to the rest of the neighbors, well, you know, I took this thing off the market and so-and-so went after me for commission. I decided I didn't want to sell. Okay, now realize too, if you give them a cancellation that says they owe you nothing, then they owe you nothing. There's a lot of provisions in the cancellation of a listing. Okay? But just know that is there for you.
How do you take it off the market?
How do you take it off the market? You just withdraw. You withdraw it on the MLS.
Oh, so it's not a cancel.
Well, if you're going to take it off, you can do 2 things. It's either withdrawn temporarily or it's a withdrawn cancel. But even if it's a withdrawn cancel, you need to put in the remarks of that listing of that MLS printout, it's still under contract. So you may not be on the MLS, but there's still a valid listing agreement. Just because it's canceled on the MLS doesn't imply that there's a cancellation on the listing. Without an actual cancellation of listing, that listing agreement is still valid. All we're saying is you're not on the MLS, so it's not being marketed.
If the seller asks you to withdraw from the market and you agree to do that, you don't have to agree to cancel the listing.
No, if the seller asks you to withdraw from the market, you can agree to do that, but that's not the same as a cancellation.
Once they're under contract, we don't have to agree to cancel the listing.
You don't have to agree to cancel the listing. And also, let me bring up another point for those of you that get fed up with your sellers, that you're frustrated with them. I hear this term a lot. I'm going to fire my seller. You really can't. You can't fire your seller, not without their consent. So this listing agreement is bilateral. So as much as you're stuck with them, they're stuck with you. So if you went to them and said, look, man, I'm tired of working for you. Let's just cancel. And they said, no, I'm not canceling. I'm not letting you out of your contract with me. Then you're stuck through the term.
Heard of that happening?
Yes. Yes.
Really?
Yes.
You heard everything. You know,
So, I have so many guys that walk into my office, man, I just want to fire these people. I said, you can't unless they consent. And we had a couple in here that just said, no. Well, then what can I do? Well, then the bigger problem you run into, what did you offer to do for them?
You didn't do.
Well, no, not just that, because if you told them, here's how I'm going to market your property, and now all of a sudden you start saying, okay, I'm not going to spend as much on my marketing, and you got this whole fancy presentation that said, here's what I'm going to be doing during the term of the listing, you are stuck.
Yeah.
Because they could come back after you and say, you put it in writing, this was your program, and now you're not delivering, you owe me. So be very, very careful when you start making those commitments, because this is not a unilateral contract. This is a bilateral contract. So when those guys are, when those sellers are interviewing you, it's just as much as about you interviewing them too. Because remember, is this an employment relationship that you want? And that do you want it? I mean, when I see people taking listings for 6 months, I'm like, really? Because if you haven't sold it that quick, is that the relationship you want to be in for the next 6 months? So just think about that, okay? All right, so let's go down to D. Seller has been advised of broker's policy regarding cooperation within the amount of compensation offered to other brokers. So this is where you're going to fill in the co-opting broker commission. Are you required to fill this in? No. The listing agent has total control over what they want to pay the co-opting broker. You may get a question from the seller saying, well, what are you going to offer the other side? And if they ask you that, then you really need to answer that question. If you end up answering the question, then you might as well fill that in and document it. Now, I've seen plenty of listing agreements that were 6% where the listing agent took 3.5 and paid 2.5.
Right.
And you bet you're going to get the phone call when the deal closes and say, why did you make more money than me? So be prepared for an answer, whichever answer that may be. And one of them could be, well, look, you know, this was a relocation deal.
Yeah.
And I'm paying 40% referral fee on relo, so at the end of the day, I'm still coming out with the same amount of money as you. Or I'm doing a bunch of staging for these guys, so I'm spending extra on marketing, and that's why I took a little more compensation. But you do need to be prepared for the phone call, because it's going to come. It will come. Whatever, just be prepared. That's all I'm saying. When you don't split it 50-50, be prepared.
Can the seller direct you or request that you pay a certain amount?
Can the seller direct you or request that you pay a certain amount? Absolutely.
Yeah.
Absolutely. It's their money. It's their money. So, for example, if you took a 5% commission and the seller said, look, I want the co-opting broker to have 3, you're only going to get 2, then you have to make the decision if you're good with that, that I'm okay to take that listing, but I'm only going to get 2 because they want to pay 3 to co-opting broker. So yes, they can. They can tell you, here's how I want it divided.
And then at that point, it's up to you if you want to take.
At that point, it's up to you whether you want to take the listing and move forward with it, okay? Let's go jump down to F. Seller represent the seller has not previously entered into a listing agreement with another broker regarding the property unless specified as follows. And let's do F1 and 2 right away. Seller warrants that seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following individuals or entities. So if you're involved in a situation, especially when you're dealing with an expired listing or a canceled listing, you need to get a copy of that listing if you're going to go in there and find out what their safety net provision is on that other listing. So you want to see what did they sign up for on their safety net provision for those number of days, and ask them, do they give you a list of names of people who are excluded? Because the seller usually, when they're signing up with you, they don't remember. Did you receive any offers on this property when it was under contract with this other agent? That they'll usually remember. You have a copy of it because you want to take note of the names that are on there. Because if those folks show up, again, under their safety net provision, that broker who brought them, that listing broker is going to be entitled to compensation.
That happened to me.
So that broker will be entitled to compensation, and you will not be. You will not be. So that listing broker is still then considered procuring costs. The buyer's broker, may still be the same buyer's broker. Now, if you saw that there was a name there and it was listed with somebody, but a buyer, one company brought this buyer and they negotiated, but they didn't put the deal together, and all of a sudden you see the same buyer show up, or that buyer shows up at your open house and says, hey, I want you to write the offer for me, you're going to still have a problem.
Yeah.
Because the buyer's broker is going to have a claim for procuring costs. Saying, hey, I'm the one who procured that buyer for that property. So be careful with that. And anytime you get wind of that, you got to notify that broker who brought the buyer in the first time and say, look, we have a problem here. We have a potential problem here. So even it was even during your listing period, forget that it was a prior, it was even during yours, because someone's going to argue over the buyer's agent commission. May not be an issue on the listing agent because that may not have been that may have passed. But there could be an argument over a buyer broker commission. Okay? And you're going to notify, you're going to let the broker who's now representing that buyer know, your buyer wrote on this before. Your buyer wrote on this last month, and they went back and forth, with my client. Now you're showing up here. No. I'm going to notify the other broker, because what's going to happen is that if you don't do that, you as a listing agent will be sued by the previous broker, because the compensation stems through your listing. So you're going to make them both aware of the fact that we got a problem here. You guys better work this out, because I'm going to hold back this commission until you guys resolve this. So that's what you'll need to do in that type of scenario. All right? But if it's another scenario where it's one of those folks who was on their list, then you're going to walk away. You're going to say, hey, I can't represent you on this buyer because your previous broker was a procuring cause in that buyer. Okay? Make sure you get those names, though, and exclude them on your listing.
Why did you walk away if you knew that they wrote an offer to buyers with the other broker?
So here's the thing. If it was during the previous listing and they were writing an offer, okay, the same buyer came in during your listing, you saw that they wrote a contract before. That previous listing agent has his safety net provision. You're still within it. You wouldn't get paid as a listing agent on that. That you won't get paid because they already were procured by the prior listing, and they should be actually excluded on your listing because you know about it. So once you know about it, you're out.
So even if you didn't get anything written on that, just the fact that they wrote the offer constitutes that.
Correct. So if you go back to our safety net provision, that's exactly what it says. So if it was listed previously, so I had the previous listing, okay? Now the listing is going to somebody else, but my listing had a 60-day safety net provision. and somebody wrote an offer on the listing, okay, on my list, but we weren't able to put it together during my listing period, and it expired. My listing expired, you came in and you get it. And now that same buyer comes back, even with the same agent, and says, my people still love that house. We've been looking at other homes. It's a week later. Here's what you countered us at last time. We'll take it. We're going to rewrite it at your price. You're not going to get anything as the new listing agent. Me as the previous listing agent, I get the listing commission. I get the listing commission.
But they would.
Okay?
How would I know about it?
Because you have to ask the question. That's what I'm saying. You already knew it expired. You knew it's been listed before. You're going to ask. Okay, who wrote offers on this? Who saw this?
It's better than going to
Okay?
arbitration.
So you lose in arbitration. It's a no-brainer. If that person wrote an offer and your listing expired 2 days after they wrote the offer, during counter and this and that, you never got an extension, okay? And now they say, I'm fed up with Bill. I'm going to go somewhere else and sign a listing agreement. But now that same broker comes back that was negotiating with me before and says, you know what, we didn't find anything else. We're going to come back to you and we're going to give you exactly what you want. I, as the previous broker, get the listing compensation. Hang on one second. Go ahead.
What are the options for the second listing broker in that scenario?
So Bonnie's question is, what are your options? Look at the safety net provision. That's why you want to get that safety net provision. And on the safety net provision, if they left it blank, even if they left it blank, you might still have an issue in the case where they actually wrote the offer. But it's actually 0 days. So you have a stronger case to say, sorry, it's not yours anymore because nothing's protecting you because you had 0 days. If they had 30 days, you literally have to make those guys wait 30 days when that thing expires, and now they can write it up, and you would get it. You would get it because the safety net provision basically states, hey, it's only good for 30 days. Now, they might try, previous listing broker might try to make an argument that that's still my deal. I still procured the cost. I was still the procuring cause there because it came through during my time period. You got a stronger case though, without having that without having the safety net provision, and the time has been a lot longer. So the further you get away on time, it starts to break what's called the causal chain of events. The shorter the time period, the causal chain of events is still in place. It's no different than if you took the scenario not on the listing end, but on the buyer's end, where you're out representing a buyer on this deal, and you can negotiate back and forth, and they say, yeah, Bonnie, we'll think about it. And now they go call Uncle Frank and say, hey, we got a deal. We know exactly what these sellers are going to take. I want to go with you. You write it up because I know you're going to give me some money back. I can tell you exactly what to do. And Uncle Frank walks in, writes up the deal, and then presents it to the listing agent. And the listing agent, if they're good, says, I've seen these guys before. What are you doing here? They were here with Bonnie last week. You know, well, no, they got tired of Bonnie. They fired Bonnie. You know, and they don't want to use Bonnie anymore. What I'm saying is, it's not that simple. Bonnie, you know, whoever that listing agent is, should be calling Bonnie saying, your buyer showed up with another agent. And they wrote an offer with another agent. You know, etc. Just want to give you a heads up, and then you're going to tell Uncle Frank, hey, I just want to let you know, I've alerted their previous agent to the fact that you're now representing them. You guys are going to have to work out how the compensation is going to be split. Okay, a little different scenario than on the listing side.
Split, you said.
Well, split or however you want to do it. Or whatever. Otherwise, I'm going to put the money aside. You guys go to arbitration, and when the arbitrator tells me who I need to pay, I'll pay that person. Because I'm not going to be involved. Because the listing agent will get dragged into this because it's their listing agreement. That's where the compensation comes from. Any more questions? I thought.
I got the answer.
You got your answer? Okay.
Bill, I have one.
Yeah.
You also can wait till that listing period that they put on that safety net. I mean, that amount of days is over to be listed if you're going to be the second agent. Is that correct?
I wouldn't do that. Why would I want someone else to come in and list it? If you wait till listing, the safety net period expires. No, don't wait for that. Just put your exclusions in paragraph F. Who's excluded? And put the time frame if you want. These are excluded for the next 30 days or 60 days. Because the other scenario you might have is a seller may tell you, hey, look, I have a friend of mine who may want to buy this house. And if I bring them to you, what are you going to give me? What's the deal going to be? And you may tell them, okay, I'll tell you what, I'll work with you provided they buy it in the first 15 days. That way I'm not deep into my marketing per se or whatever. So they might want an exclusion for somebody that they have even. Forget a prior listing. This has never been listed. And now they're telling you, I got a couple of friends of mine who are interested in my house. And I may want to sell it to them. And if I sell it to them, either I want to be excluded, no compensation at all to you, or you're going to do it for just X amount of dollars to handle the paperwork. And if you decide you want to do that, then you make it time sensitive. Okay, I'm fine with that, provided they buy within X number of days of me taking this listing. Because even if they bought after that, it's full commission. So you can do that also. And that happens a lot. That happens a lot. People have somebody that they already know that might want to buy it.
Yeah.
All right?
No. So what happens when you're the listing agent and other brokerage makes the appointment? Example, Redfin made an appointment to show my listing, but they were late and the people were standing in front of my listing, and I went to prepare and turn lights on for the showing, and the people came early, so the agent was late, and I didn't let them go in yet because I waited with them I opened all the lights and got it prepared, but I didn't let them go in yet. Wait for their agent. But could I have shown it and then?
Can you show up when their other agents late? Of course you can.
Oh,
So and just showing the property, you're not giving the buyer away. Just showing the property, I hate to tell you, isn't necessarily enough to be considered procuring cause.
But they asked me to represent them. I said I can't because you already made an appointment with Redfin,
Well,
and I don't want to be in the middle of that.
This is that's a whole different question.
But
how you would handle it if they have an agent, respect the agency.
They just made an appointment by phone. Do they really have an agent?
I don't know. I'm telling you. You don't know the circumstances. Okay?
Could I have made that offer?
Let me finish. You're there to sell the house.
Yeah.
If someone tells you they're working with an agent, that's a red flag. Because the reason why I'm telling you, just showing it doesn't qualify you as procuring cause. So put your own self in a scenario where I've spent months working with these buyers. I've got them pre-qualified. I've actually written offers for them before and got them rejected. And now they show up in another house and they tell you they're working with an agent, but the agent's late. They say, well, why don't you just show it to me, and if we like it, we'll write it with you. You're going to lose a procuring cause case. They've already had an established relationship, with these agents. They can show that there's been this established relationship over time. There's a lot of factors that go into that. Out of professional courtesy, why would you write that? Why would you write it? If you know for a fact they have an agent, and they've told you they have an agent. It's no different than somebody coming to you saying, I have an agent, but I know you're the listing agent, so I'm going to write it with you just so I know I get it or I get a better deal.
Yeah.
It doesn't work. It's classic for you to lose a procuring cause case under that. Okay?
Well,
all right.
Let me explain.
I don't want any more explanations. No. We're going to move on. We're going to move on. Okay? I got to move on. If you want to talk to me later, you can talk to me. All right? All right. Items excluded and included. Unless otherwise specified in real estate purchase agreement, all fixtures and fittings that are attached with property are included, and personal property owners are excluded. Make sure you fill this in, but even more importantly, it doesn't even matter if you fill this in, and it doesn't even matter if you list the items that are included or excluded in the MLS. What matters is what's on the contract. You could have it here. You could say that these items are included. Washer, dryer, refrigerator are included.
Yep.
And the contract comes in and is silent on the washer, dryer, and refrigerator. They don't go and they don't stay. And that may be a negative. And the reason why it may be a negative is that the seller may say, I don't want to move those things. So what you would have to do in that kind of contract, you literally would have to counter the offer and say, washer, dryer, refrigerator to remain with the property.
Okay.
But the bigger scenario that we normally see is that the seller looks at it and says, oh, I offered the washer, dryer, refrigerator, but the contract didn't say that, so now I'm going to take them. And then the buyer shows up and says, where's my washer, dryer, and refrigerator? The MLS printout said they stay. And the agent missed it. Forgot to check it. They don't stay. It's what's in the contract. It doesn't matter what's in the MLS. The RPA even says it doesn't matter what's in the MLS. Whatever's on the contract is what it is. That's it. Paragraph of the RPA says anything on marketing materials, MLS, or brochures are irrelevant. Are irrelevant. Okay? So it's great. The reason why you put it here is it's supposed to remind you, okay, that this is what they want. Okay? But you have to make sure when you're reviewing the offer when it comes in that if they said washer, dryer, refrigerator stay, and you don't see washer, dryer, refrigerator check there, you know, I would be giving the buyer's agent a phone call saying, did you miss this, or do you guys just not want them? Because maybe they don't want them. Maybe they're old and they figure, I don't even want them. We got our own stuff, and I don't want them. Okay? Leased or not owned items, pretty self-explanatory. You know the big one is solar. Solar right now is the big. And if it's a lease, get a copy of the lease. Get a copy of the lease, post the lease under associated documents. Let the buyers look at what the lease terms are first before they submit their offer. They need to know that. They need to know if they can even assume the lease. Okay? Liened items, same type of scenario. A lot of the solar systems may show up as a lien, you know, on the pre. May show up as a lien on the pre. Windows and doors, I'm not sure about that one. But, you know, alarm systems are kind of the same thing. Water softener is another big one. Most of those are generally leased. So if it's a leased item, like a water softener, it may not stay. They don't own it. So any leased items, you got to make sure that the buyer is aware that these items are leased. Okay? The MLS, that's pretty self-explanatory. I'm going to spend a lot of time on it. Yeah?
For the liened items there, let's just say for HVAC, would this include like a case lien as well?
HVAC, yeah. If you look at that pre and you see there's a pace lien on there, yeah.
Would this be included?
Yeah, it could be, yeah. So most of the pace liens, I think, are with solar, from what I've seen. But yeah, so if you see that, then you want to know, hey, click on that link and see, hey, what's covered here. Benefits and opting out of the MLS. Again, I can't tell you guys enough that you should not opt out of the MLS. I mean, it's just, I think you set yourself up for potential lawsuit, even when you have everything signed. It's not a good idea. And to me, it's like, hey, you should always be on the MLS. That's my personal take on it. Let's go to page 3. If you look at broker and seller's duties, all right? Broker agrees to exercise reasonable effort and due diligence to achieve the purposes of this agreement. Unless seller gives broker written instructions to the contrary, broker is authorized but not required to order reports, disclosures, including those items specified in 7C, which we'll get to. Advertise and market the property by any method and any medium selected by broker, including the MLS internet, to the extent permitted by those media, control the dissemination of information submitted in any medium, and disclose to any real estate licensee making an inquiry the receipt of any offers on the property and the offering price of such offers. So that goes back to what we talked about in the dual form, about disclosing, hey, here's the offers I got so far, here's how many I got, here's the price I got, etc. All right? Seller agrees to consider offers presented by broker and to act in good faith to accomplish the sale of the property by, among other things, making the property available for showing at reasonable times, subject to paragraph 3F, which we just went through, referring to broker, all inquires of any party interested in the property. Seller is responsible for determining at what price to list and sell the property. That takes you guys out. Now, on the investigations, if you're going to order reports, check the reports. Because if you don't check them, and you go ahead and order them without some type of authorization in writing from the seller, whether it be on the listing agreement or an email at least, guess who gets to pay for them? You do. So you will pay for them if you don't have the authorization to order them. All right? So make sure you get the authorization. Let me see. Agency disclosure, I think we covered that. All right, let's go to the next page. Security insurance showing audio and video. Broker is not responsible for loss of or damage to personal or real property or person, whether attributable to use of a key box safe, showing of the property, or otherwise. Third parties, including but not limited to appraisers, inspectors, brokers, and prospective buyers, may have access to and take videos and photographs of the interior of the property. Seller agrees to take reasonable precautions to safeguard and protect valuables that might be accessible during shows in the property and to obtain insurance to protect against these risks. Broker does not maintain insurance to protect the seller. Persons visiting the property may not be aware that they could be recorded by audio or visual devices installed by sellers, such as nanny cameras or hidden security cameras. Seller is advised to post notices disclosing the existence of those devices.
Really?
So what does this say? You're telling the broker, look, people can come in here with their cell phones and start taking photos of your home.
Yeah.
On one hand.
Yeah.
On the other hand, buyers and agents, beware, you may be monitored.
You might be
Not only by video, but by audio.
Oh, wow.
The audio is becoming big. So if your buyers are going to have a conversation with you regarding this property, take it outside. Because in this day and age right now, I can honestly tell you that I would say at least 50% of the homes are monitored somehow. And the one thing you don't really know, you can see the camera, but who wants to take a guess as to whether there's audio with that camera? So when you're walking through the house, be complimentary. If you're going to say anything, or say nothing.
Set them up.
The most important thing is do not say anything derogatory about anything in the house, and forewarn your buyers before they walk into the house that you cannot presume that signs will be posted about cameras or audio. This is becoming extremely prevalent. It's kind of sad, but that's how it is. So before you walk into a house, please tell your buyers, let's go through the house. If you have questions about the house, I'm happy to answer them for you. But let's not make any other statements about the house other than potential inquiries. We may be being monitored. And when we get outside, far enough away from the front, then let's talk about what you thought, or let's wait till we get back in the car and talk about some of your thoughts on the house. Okay? So that's all I can tell you right now. This is the age we live in. Yes?
What about on open houses? What do you do?
What about on open house? That's a great question. So I've had a couple listings where, I tell people when they walk in, so I'll let you know we got video and audio monitors. I mean, I'm going to be honest.
If you do.
I'm going to be honest. Because to me, I want to disclose.
Yeah.
You're being monitored. So I'll put them on notice. And I've had 2 of my clients that have that. I mean, I was holding an open house one day and my client's texting me about this couple that just walked in. I'm like, okay. And I'm like, oh yeah, okay. So from that point forward, I was like, man, I'm telling people, hey, my folks have surveillance on this house.
But if you know them, if you don't know them.
If you don't know, you should be finding out right when you're taking the listing. Hey, do you have video monitors in here?
Sometimes the sellers, you as listing agent, they're watching you.
That they are. They're watching you.
I know I had a listing like that. I knew, and all I did was just talk so nice about my seller.
I agree. I agree.
Always be nice when you're in the house, because you never know who's listening.
Oh, and please, do not talk about price. Do not say anything about price, or at least the fact that the seller could be negotiable. Bonnie,
Do you have a
question?
video here in your building?
Yeah.
I don't have any monitors in here.
Of course, you should answer.
This isn't Timothy Crofton's office.
We're being videoed.
You answer the question.
Okay, all right. Any other? Yeah.
So does the seller disclose to the selling agent, the listing agent saying, hey, there are cameras, there are something, does he disclose to the listing agent?
He should, but if he doesn't, you should ask. If you haven't seen them for yourself, you should ask, hey, do you have any video surveillance? Video and audio, quite frankly. So if he lies, there's not much you can do about it.
Just still be nice. Just still be nice.
But the rule is, just be nice. Don't say anything derogatory. When you're inside the house, don't say anything derogatory. Yeah, because like there's talking in this agreement. Could be a hidden camera.
You know what I mean?
It's not a hidden camera if he tells you about it.
Alexis.
Okay?
You never know.
So anyway, all right. Paragraph 11. Photographs and internet advertising. So in order to effectively market the property for sale, it is often necessary to provide photographs, virtual tours, and other media. Seller agrees, or if checked, does not agree, that broker may photograph or otherwise electronically capture images of the exterior and interior of the property for static and or virtual tours of the property by buyers and others for use on broker's website, the MLS, and other marketing materials and sites. Seller acknowledges that once images are placed on the internet, neither broker nor seller has control over who can view those images and what use the viewers may make of the images, or how long such images may remain available on the internet. Seller further assigns any rights in all images to the broker and agrees that such images are the property of the broker and that the broker may use those images for advertising, including post-sale and for broker's business in the future. So here, the seller's giving you permission. Once you pay for that stuff, it's yours. It's totally yours. But what the issue you guys are running up against right now has nothing to do with the seller anymore. It has to do with the buyer. The buyer moves in and says, look, I want you to take down all those photos because it's an invasion of privacy for me. So I want you to take those things down. I don't want them up anymore. Well, this listing agreement gave you the right to keep that stuff posted. So you don't have to do that. But I'm finding that most agents are accommodating. But the issue then, though, you have to tell the buyers, I can't guarantee that those photos are going to come down on all the other third-party sites. I have no control over that. So they may have already captured those photos, and they're just there to stay. They're not taking a feed anymore from the MLS. They've got them. So I can't promise you that. All I can promise you is what's within my control.
We need to have something like that in disclosure and purchase agreement.
Well, I mean, yeah, you might look at something
Because,
where,
for the buyer to know, because the buyer doesn't.
right, the buyer doesn't know this. That's correct. That might be something.
Routinely, when I put my listing sold, I take all the photographs except the, primary one off.
Why do you do that routine?
Because at least half the time I get calls from the buyer's agent about 3 months later that the buyer wants them all down.
Yeah, so.
And Zillow too. And I said,
Yeah, so that might be something that CAR may need to work on in the RPA. So B, seller acknowledges that prospective buyers and or the persons coming on the property may take photographs, videos, or other images of the property. Seller understands that broker does not have the ability to control or block the taking and use of those images by any such person. If checked, seller instructs broker to publish in the MLS, the taking of images is limited to those persons preparing appraisal or inspection reports. And seller acknowledges that unauthorized persons may take images who do not have access to or have not read any limiting instruction in the MLS. So they can check that box, but still they're saying, hey, you're still telling them, look, I can check this box, I can put it in the MLS, nobody's allowed to take photos, but unless they've seen that part of it, which would have to be in the public remarks, if you wanted the consumer to see it, it'd have to be in the public remarks, not the confidential remarks. Mr. and Mrs. Seller, they still may come in here and take pictures, okay? Now, on the picture piece, if you're hiring professional photographers and you don't know what the contract with them is, you may want to have your photography people sign the property images agreement. Because the property images agreement, because with a lot of photographers, they're going to tell you that the photographs belong to them and not you. Okay? That's their photos, not your photos. They're just letting you use them for marketing, even though you paid for them. So this private included this property images agreement only in the event that if you're not sure about what your photographer's policies are, then you have them sign this, because this states that those photos belong to you, the real estate licensee, and that the photographer is only allowed to use them for their marketing purposes to show, hey, here's some examples of great work that I do. So if you don't know what your existing relationship is contractually with your current photographer, then I would get this signed to be on the safe side, because now you know the photos actually belong to you. Okay? Yeah.
Bill, on this photo bit and eliminating them from the MLS, how does that benefit the appraiser on the appraisal process? It's kind of a hindrance to eliminate them, I would think.
Yeah, Bonnie's question is a good question. How does eliminating the photos off the MLS benefit an appraiser on a future sale for comps? It doesn't. It doesn't. So what I'm saying is that, look, you're not required to take them down. There's nothing that requires you to take them down.
Let's say you have to.
But the problem is that you get a buyer who's really upset, and pretty soon they're saying disparaging things about you on Yelp. You know,
Or
so,
seller.
or whatever. The seller doesn't care. The seller's left.
My seller made me take them down.
They don't care. Why should they care? They don't even live there anymore.
No, my seller made me take them down.
You don't have to. Because the fact of the matter is they signed that listing agreement.
Yeah.
All right? Once they give you that permission. But that's a good question, Bonnie. Lockbox I don't really need to go into. If you're going to do additional terms, here's where you would do it. The additional terms piece is great places for triggers, such as you're not happy with the list price, but you agree to go along with it. So instead of having to do an MOT, you build it right into here. If this property doesn't sell or receive an offer within 30 days, the seller agrees to reduce the price to X. So it's already built in. So it's one of those deals where you really are not happy with the list price, but you don't want to walk away from the listing. You tell the seller, I'll do it your way for 30 days. If we don't get any activity or any offers or anything on it within 30 days, we agree right now, here's what we're going to lower it to. Or if you've got a dual variable commission, and if you sell it yourself, here's what the commission is going to be. These are places where you can put that in there. Any other terms, your staging stuff can go in here. You agree to pay for staging, or you'll reimburse for staging, whatever you want to work out on your staging, put that right here in the additional terms. Because you may have an agreement that the seller agrees to pay for staging. However, upon the close of escrow, listing agent will reimburse the seller for staging up to X amount of dollars. So you can put that in there. All right? And sometimes that's a better incentive to let them pay for the staging up front, and then you reimburse them, as opposed to you paying for the staging up front. Now, if you're offering staging as part of your package, then you would need to put a provision in the additional terms that say if they cancel on you, or the listing expires, etc., is withdrawn, they agree to reimburse you for the staging. Okay? Let's see. Let's go to the next page. Last page of this thing. Let's go down to 21. Ownership, title, and authority. Seller warrants that seller is the owner of the property. No other persons or entities have title to the property, and seller has the authority to both execute this agreement and sell the property. Exceptions to ownership and title are as follows. There really should be no exceptions.
Yeah,
If you have exceptions, you have a problem. Now, the question always comes up, do both sellers need to sign the listing agreement for you to have a valid listing? No. You can list with one. It requires two to sell. So what's the point of listing with one? Because if you don't get the other person signing, they're going to look at you and say, I never agreed to sell this property. You got one signature, which makes the listing a valid listing, but contracts can't be signed with just one signature. So for you guys, to some degree, and I hate to say this, if you don't get both, you're kind of misrepresenting the listing. It's really not, it's out there on the MLS, but you have no idea whether the other person is going to sign, and you have no idea if what their situation is. They could be in the middle of a divorce. Husband calls you up and says, come over and list my house. Doesn't tell you anything about the divorce. My wife is out of the country right now, but she told me, let's get it on the market. Okay? And you do it. And all of a sudden an offer comes in, and the wife says, what are you talking? I'm not selling. I didn't agree to sell. Now you got a problem. You got a big problem. Always get both signatures. Always. It's not required, but it's the best practice. Okay?
Under that scenario, can the buyer sue and win?
Could the buyer sue and win under that scenario? No.
You can't get the house.
never had
You can
the
sue
And I'll tell you why. Because what is a listing? Is an offer to sell. And there's no contract until you have offer, acceptance, consideration. But it's pretty embarrassing as an agent to not know that you're going to be able to sell. So no, the buyer's not going to be able to sue you because the seller can even change their mind. You could have both signatures. And now they call you, Bonnie, you know what? My job transfer got canceled. Take it off the market. I'm not going to sell. I got this offer in my hand. We're not selling. So you have nothing. It's just embarrassing.
You know, I have one where the wife will sign the listing agreement, and she tells me she's not signing a purchase agreement. We've been waiting for about 5 years until he convinces his wife. I think it's never going to happen.
If you are dealing with a representative capacity situation, like we talked about earlier, check this box if you know you're dealing with someone else who's signing. I'm not going to go through the seller advisory, but just be aware. The last thing I want to go through is the SELM, the seller exclusion.
Yeah, very important.
So, paragraph 7, beware. Bay East is looking at this. If you put in here, do not submit the property to the MLS for a period of 30 calendar days, and you're on day 40 and you're still not on the market, get an extension on that. Or embellish this. Say it's 60 days, because you can still come on sooner. So Bay East is checking their SELMs for either calendar days or the actual date. So be broad on that. If you think that you're going to have some delays, then drag it out a little further, because you can always come on earlier. Okay? So I can just tell you, I got a call from Bay East on an agent. We were already pending. Property's pending. They said, hey, your SELM is expired. So I looked up the property and I said, called her back and said, it's pending. Doesn't matter. It came on the market this day. It was supposed to come on this date. I said, it was a week difference. Tell them we need an extension on the SELM. I said, it's pending. Didn't matter. So that's what they're looking at this stuff. They're looking at this stuff.
You don't give them this, and you don't have a coming soon sign.
So,
There's no way they know about it.
So here's the thing. So Greg's point. Greg said if you don't give them that, you don't have a coming soon sign, most likely no one's going to know about this. There's only basically one way. Someone else could be knocking on doors, and they knock on your seller's door, and the seller says, oh, yeah, we got our house listed already with Greg. Well, I don't see a sign in front of it. Well, we're getting it ready. Now they could go back to the MLS and check and see if there's an SELM file. Short of that, that's probably about the only way you're going to get caught.
Man.
So if you put the coming soon sign out, make sure you got an SELM, because they're going to check on that.
Well, what's wrong with putting to be determined on that?
You can't. It's got to be a definitive date. It can't be to be determined, because you got to have a definite date. You got to have a definite date.
I've seen somebody put seller's instruction or something like that.
I've seen people put it there when it's ready.
When it's ready.
Yeah.
From what we're hearing, that's not going to fly anymore. It's not going to fly. So just extend your date out.
Yeah.
But be smart about it. Obviously, don't extend it past your actual listing agreement, because that would look kind of dumb. 150 days. Oh, I got 90-day listing. So if you want to put it 90, whatever. So just put something in there. If you think it might get delayed by a few weeks, just pad it. Pad it a little bit, or put by no later than, or up to this date, whatever. Okay.
This is mandatory now.
That's mandatory if you're not going on the MLS right away.
Yep.
Debbie.
So when your property's in a trust and the seller's in trust, do not have them sign the family such and such trust.
No, yeah, so
Thank you.
When the seller's signing on behalf of a trust,
Yeah.
the name of the trust is the Abumrad Family Trust. When they sign, they don't sign the Abumrad Family Trust. They sign with their name as the trustee. So they don't use a name of the trust signature, they use their name with the word trustee behind it. But what's nice is when you use the RCSD and they sign that, they don't have to put trustee. That eliminates that. So just sign their name and you don't need to put trustee. You will need to do that though when you're signing papers at the title company. They'll require the trustee moniker on that. But for our paperwork, once the RCSD is executed, we already know they're signing as a trustee. So you don't have to have them sign all the documents as a trustee.
You have a trust situation, one of the married people dies, do you need a copy of the death certificate, a certified copy of the death certificate?
Trust situation, one of the trustees dies, yes. Do you need a copy of the death certificate? Yes. You'll need a copy of the trust and a certified copy of the death certificate, and you might even need, if it's a case of if it was a case like of a joint tenant, you would probably even need an affidavit of death of a joint tenant. Okay? So, any other questions?
If you write 90 days over here and you're listing before that, so you don't have to change to the actual date of listing.
No, if you write 90 days on the SELM that you're going to come on the market,
Within 90 days.
within 90 and you come on in 60, you're fine.
Oh, then you have to
Okay.
extend your listing because you lost all that marketing
You
time.
don't, no, what did I say at the beginning? I said, if you already know you're not coming on right away, you should already be building the listing date in. You should be extending it from the beginning because you're not going to automatically get that. So build it in from the get-go, all right? Any other questions? All right, thanks you guys.
Thanks, Bill.
Thank
You're
you.
welcome. Good class.
Oh, me too. Do we have?
McMurray,
Yes.
my favorite leprechaun.
You're early.
Yeah, I got my green on. Yeah, I was telling my great grandfather. My dad showed me a picture. I wasn't.
You have what?
Yeah, white guy said,
It's not on the MLS? What did you call base and see if they found the SELM?
That's what I was trying to figure out.
That's what you should do. That's what you call them and say, hey, can you check on this for me and see if it's SELM?
And you heard Black Irish?
There isn't.
He's all has white cousin.
That's interesting.
So, you know what my philosophy is?